Good afternoon, everybody, and thank you for joining us. Really, truly appreciate it, and hope this afternoon finds everybody safe and well and healthy, and hopefully you had enjoyable Thanksgivings. But these are certainly unprecedented times. My team and I, we specialize in multifamily sales here in South Florida, and on a given month, we talk and meet with hundreds of owners, and there's been consistent themes given our interesting perspective, right in the front lines, and consistent themes of issues that owners, landlords are having with their properties and with their investments, specifically because of this unprecedented pandemic, such as difficult evictions in light of the CDC moratorium, issues with non-paying tenants, whether or not they can afford to pay, and growing past due collections, rental rates. We often run into owners that the rental rates are lower than we feel they should be, and it's been a consistent theme lately, especially the last few months, and high expenses. So it's something that we're taking a look at almost on a daily basis, and confusion with documentation. What kind of changes should be made to leases? What other kinds of information should they be sharing and documenting with their residents? And this is something that we're going to cover during this next hour. So thank you for joining us. I'd like to say that we are joined and really privileged to be joined by Phil Rosen and Adam Cervera of Becker Lawyers. Phil is the chair of the firm's real estate practice group, and Adam is a member of the firm's business litigation and community association practice group. These guys are literally my go-to experts on every topic we're going to discuss today, and we are really fortunate to have them here today. So, gentlemen, I'd like to thank you for being here. And I think we'll start with Adam in terms of best practices and the CDC guidelines, and just a basic overview of what this moratorium is and how it affects owners. Could you give us an overview?
Absolutely. And first off, I also want to thank everybody for taking the time to join us today on this webinar via the Zoom platform. And I want to thank Steve for agreeing to moderate the proceeding and for the kind words. So I'm going to give an overview of where we are as far as this federal moratorium is concerned with the CDC order that was entered back in September. But before I really jump into any of that, I want to say the following, just to make sure that everybody's clear and everyone can take a collective sigh of relief. Eviction lawsuits can still be filed in the state of Florida, in Miami-Dade County, in Palm Beach County, in Monroe County, in Broward County. If you own property and you have a non-paying tenant, you are still permitted to file an eviction lawsuit against them. Now, part of an eviction lawsuit, obviously, the last piece of the puzzle, if you will, is removing them physically from the property, which you cannot do pursuant to the moratorium, which I'm going to get into. But there's a lot of confusion, whether it's news media, social media, people just telling you bad information. I want to make sure I'm clear when I say you are allowed to file an eviction lawsuit right now in the state of Florida against non-paying tenants. Also, an important point, the CDC moratorium order does not prevent or negate a tenant's obligation to pay you rent. It doesn't do it. They are still ultimately on the hook for all of the monies that are owed pursuant to whatever lease agreement that you have in place with that tenant. And I want to also reassure everyone that even if you find yourself in a situation where you have a tenant who is wise to the CDC moratorium and files what's called this standard declaration, which basically puts landlords on notice and triggers the protections, you still have the ability to fight that in court if you have a pending lawsuit. It's not something you just have to say, okay, it's filed, there's nothing I can do now, I've just got to sit on my hands. That's not the case. So those are three very important points that I want to make sure everybody is very clear of as we proceed forward. That being, Steve, if it's okay, I'm just going to jump into some of the specifics of the moratorium order, just so everyone has a fair understanding of where we're at. As I mentioned before, you are still free to file your eviction lawsuit. And what's also important to understand is that the moratorium order from the CDC only relates to eviction actions for non-payments of rent. That's it. So if you have a tenant that's violating other provisions of the lease, if he's committing crimes, if he's damaging your property, anything like that, you can sue him or them, and you can proceed with your eviction action. You can have them removed pursuant to that eviction action, is the only protections that the CDC moratorium that's currently in place offer for non-payment of rent. Again, you can still file the lawsuit. You don't need to wait till the moratorium period is over, which, by the way, is very fastly approaching. It's set to expire on December 31st of this year. Unfortunately, I don't have any insider information as to whether or not it's going to be renewed or not, but certainly as soon as I hear about it, I'll be happy to pass it on to my friends, colleagues, and clients. But as I sit here today, I don't know the status of the renewal. The moratorium does affect pretty much all standard rental housing type situations, including mobile homes, mobile home parks, standard apartment buildings, and complexes. It does not apply to hotel and motel guests, but pretty much all your standard rental procedures, or properties rather, it will apply to. Now, in order for the tenants to qualify for this protection, they must file a sworn declaration under penalty of perjury, which in theory, if you violate, will subject the violator to federal criminal charges, which can include imprisonment for up to 5 years. So this is serious, obviously something that the government wanted to take very serious. And within that declarations, there's certain things that the tenants have to state, that they've used their best efforts to try to obtain rental monies to pay. They've suffered some sort of hardship because of obviously the current pandemic. They expect to earn less than $99,000 in the calendar year for 2020. They have to acknowledge and understand that they're still liable for the rent. And there's some checklists under, or there's some additional points under the declaration that they have to basically agree to when signing it. Also, I know we're in an electronic age. It specifically says in the CDC order, electronic signatures are permitted as well as hard copies. So if you have people emailing you those, you unfortunately would have to accept them if it's an electronic signature. Also, a key point with the declarations, every adult listed on the lease needs to sign one. It's not a catch-all. So if you have a lease with, a husband and a wife, and they're both on the lease, and only the husband gives you the declaration, the wife would not be protected in that hypothetical. Here's an important note as well. All of my landlords out there, you're under absolutely no obligation to inform your tenant about these restrictions and the moratorium order. It specifically says it in the order, you have no duty. Now, obviously, if they find out about it and they inquire from you, you can't, deny its applicability, but you have no outright duty to go out and advertise this to everybody. You can challenge this in court. If you file an action and you get one of these sworn declarations, you have the ability to take written discovery in a court proceeding, to take a deposition, to ask for tax returns, to ask for employment records, bank records, things like that, to basically prove the elements within the sworn declaration. So this is not something, like I said before, that you just have to sit back and accept. You can do things to prove what this is saying. Now, I know this moratorium issue has caused a lot of hardship for landlords who aren't getting paid. But I think what's important to know is it's probably not as bad as you think it is. And there are ways to work around the moratorium order to effectively get what you want. And to all of my landlords out there, I can tell you, as we sit here on the 2nd of December, and assuming this does not get renewed, if you filed a lawsuit after this webinar ended, chances are you wouldn't be getting a writ of possession with the holidays and the access to the courts that we're having now by December 31st anyway. So there's really no reason to sit on your hands should you be inclined to file an eviction lawsuit. Don't let it discourage you. There's ways to work around it and with it.
That was a great overview. Thank you. And I'm sure we'll dig a little deeper some of the questions that we've already have in. And thank you for those who have given questions, and the questions are coming in because we'll be able to dive deep. So that was very helpful. So Phil, why don't you review some of the common pitfalls in residential leases, especially now where so much documentation is needed to track all these moving targets as landlords are working with tenants officially, unofficially, casually, or very specifically with some of the non-payment hardships they're going through with their residents.
Sure. First of all, Steve, thanks so much for putting this together and having me.
Thank you.
And for everyone out there, my name again is Phil Rosen, and I am the chair of the real estate practice group at Becker. And so our group handles all types of transactions, from small residential closings through to large institutional type acquisitions all over the country across every asset class. And of course, some of my favorite transactions over the last several years have been in multifamily. Multifamily it's always been the darling asset class, because even when we're in a recession, everybody still needs somewhere to live. And so, we've got institutional clients, and those institutional clients generally have their own property management or hire property management companies. Those folks have very, very specific procedures as to how they handle things. It's really more when you get to the mid-range and most often the smaller mom and pop type owners that don't have real procedures in place, don't have standard lease agreements in place, or if they do have a lease agreement in place, they might have pulled it from the internet or might have gotten one from a lawyer 10 years ago. But that's a blessing and a curse. It's a blessing for us as lawyers because it always creates more work for us, but it's a curse for people because they're not making the best out of their investment. And sometimes people get a little bit penny wise, pound foolish about doing things the right way. And by the right way, I mean hiring an attorney to help set up your documentation. Look, we all know that you need a written lease in Florida for a tenancy of a year. They just in July removed the requirement for there to be a witness on a lease for any lease over a year. That was a little bit of a problem for us as lawyers because some of our clients didn't have their commercial leases signed with a witness, but we're overcoming that. But look, the most important thing that I'll tell you is that every agreement that any landlord has with a tenant should be in writing. It's basic, but people forget that. And sometimes people think, well, he's a good tenant, or she's a good tenant. We have a good relationship. It's okay. We shook hands. They've paid their rent on time every month for the last 2.5 years. I don't have any reason to think that there should be a problem. But, when times are good, things are fine, right? But there's not a problem until there's a problem. And when that great tenant of 2.5 years loses their job, or has some sort of medical emergency and they can't pay the rent, that handshake deal you had with them, you're going to the bottom of the list. And so the most important thing is get it in writing. Now there's varying degrees of getting it in writing. You have the call from the client of saying, well, the tenant sent me a text message. Is that binding? Is that a part of my lease? So, no, of course it's not part of your lease. It's just a text message. You don't know that they actually did that. What if their daughter or son or mother or spouse typed that in without their knowledge? So no, text message communications, emails of somebody saying that they're agreeing to something, they don't count. Now, could there be evidence if there is a lawsuit? Yeah, it might be, but there's no reason not to do things the right way. So when COVID started, we got a tremendous number of phone calls from our landlord clients asking, what do I do? And I told them, what you need to do is you need to ask for full disclosure from the tenants who are asking you for relief. Just like your lenders are asking you for full disclosure, make sure that you get full disclosure from your tenants. Talk to your tenants. But no matter what you do, you should have an amendment to the lease signed indicating what you've agreed to. This way there's no confusion. This way people's memories don't get fogged. Some of our clients asked us in the beginning to prepare a form of a lease amendment for them where they only had to fill in, the name of the tenant and maybe the deferred rent that they agreed to. But it certainly makes Adam's life easier when I refer my clients to him when everything is, quote, papered up. So that is probably the number 1, 2, and 3 pitfall for landlords. The fourth one is making sure that your leases that you use are up to date. While Florida laws haven't changed that drastically with regard to residential leases, they do change. And it always is a smart thing to have an attorney review a lease. Just because you pull a lease form from somebody online doesn't mean it's a good lease. My favorite is, well, it's just a form lease that I found. It must be right. Well, there's all different degrees of leases. Look, the Florida Association of Realtors has a lease, and most of the residential brokers use that lease. It's got some good points. It's got some bad points to it. So there are times when that lease is appropriate, and there are times when it's not appropriate. That really depends on the situation. I've had clients call me and ask me to take a look at the Florida Association of Realtors lease. In some situations, I've said, you know what, it's fine for your purposes and what you're doing here. But always really smart to have an attorney look at it. I know that this is self-serving, but we have jobs for a reason, and that's because people don't use us, and you're either going to get us coming or we're going to get you going. So really make sure that everything is papered up and make sure an attorney reviews your lease. And then third, if you are having trouble with a tenant, make sure you understand what you can and cannot do. You cannot remove their front door. You can't change the locks. You can't inspect their apartment at 3 a.m. because you're trying to harass them. Really, that's when somebody
calls. It's actually one of our questions.
What, if they can go in at 3 a.m? So, yeah, I mean, that's when people call me. That's when I'll get Adam on the phone and he'll tell them very nicely, yeah, you can't do anything. If you wouldn't want it done to you, don't do it to them. That's a great place to start, and then we'll help you finish.
That's terrific. And if we could elaborate a little bit, actually a question just came in. What protections should landlords be putting in place in their either current lease or new leases with new tenants coming in the midst of the pandemic, so that they're not signing a lease where somebody comes and just doesn't have to pay from day one or refuses to pay from day one? And I guess also just some common pitfalls that you see in leases generally that they should be looking out for.
Sure. Adam, you want to take this or you want me to?
Either one. As far as the COVID, the COVID pandemic is concerned, I've gotten situations where landlords have come to me and say, hey, I've got this prospective tenant and, what should I do? They're asking for a little bit below what I wanted market, but, for whatever circumstance, they've got to come in. And my standard answer, if you will, is, well, do a little bit of homework, do a little bit of an investigation on this individual. Are they working? Can we get some sort of letter from their, their employer showing that they're that they're currently working, that they have a stable income? Because the last thing you want is to just have somebody show up with, okay, here's a couple $1,000 for the first month. You think everything is great. And then, the next month rolls around and all of a sudden, well, I can't do this. And the moratorium order has now been expanded for another 3 or 6 months. And now you're caught sort of in a bad place where you're not getting any income, and you can't, although you can sue them for eviction, you can't actually remove them and make the property income producing again. So I guess my tip, and I'll let Phil chime in as well, I guess my tip would be, do your homework on who you're allowing in your properties. Be diligent. There's a lot of companies that can do these background checks and find out very important information about who you're going to be allowing into your properties.
Sure. One other thing is checking people's credit. Most of the institutional owners, they run your credit. And if you have a tenant that refuses to allow you to run their credit, I think your answer is right there. You could request more money up front. You can ask for additional security. I've had landlords ask certain tenants for 6 months of rent up front, and sometimes they pay it. If they need a place to live and it's important enough to them, well, then, that's how that works. Look, as long as a landlord is not discriminating, right? And you can't discriminate based on age, race, gender, etc. But you can certainly discriminate against somebody who doesn't have a job. You don't have to rent to that person, right? You don't have to rent to somebody who's had 7 jobs in the last 2 months. You don't have to rent to somebody who can barely scrape together the rent or at least the first month and the security deposit. Use your business instincts here and realize that I know this is going to sound a little harsh, but the tenant who's coming in who has bad intentions, they don't care about your family. And as a landlord, you're doing this because you're making money to put food on the table. Most multifamily owners own one building. And that is their main or secondary source of income. And, it's a matter of, are you going to let somebody come in and essentially steal from you? And so you need to, as long as you don't discriminate against them for the reasons that I enumerated, you can certainly discriminate for people who you don't feel are going to be able to pay you. You have to be careful. And again, if you're not sure, that's when you call someone like Adam and review the situation and maybe send it to Adam and say, hey, Adam, here's all the information I have. I'm not comfortable, but I want to make sure I'm not violating any laws by denying them. That's worth the time and the effort. So as far as the leases are concerned, I'm just going to anchor back, Steve, to what I said before. Other than I've had some landlords ask me to draft information for them, draft language for their lease, stating that the information that they gave them about the lease in order for them to obtain the lease in their application, finances, otherwise, are true and correct. By doing that, if it turns out that it's not, you have a potential fraud claim against somebody. And while that's not going to really change Adam's rate of success, it should certainly let people know that, hey, I'm not the landlord to mess around with. If you're looking to get away with something, you need to go down the block. Just don't come here.
That's great. Thank you. And are there any pitfalls, 1, 2, 3 that you constantly see as just not again? This, that's just people are making the same mistake over and over and over that just keeps you busy.
This is an Adam question.
I'll jump in here, and I don't know what it is. Maybe it's just the flavor of the month, or I guess the flavor of the last several months. If you're using the Florida Division of Realtors, the standard lease agreement that Phil referenced earlier, one of the glaring omissions from that is there's not really a space to write in who are all of the adult occupants that are going to be residing in the property. I'm handling several pieces of litigation now where tenants have sued my landlord clients, and you have 3 or 4 plaintiffs, and they're claiming that the one guy that I knew about that I thought I was was a single gentleman was living there. It turns out his cousin, his grandfather, and somebody else was living there, and something happened. It was a mold claim, a piece of the roof fell down, or what have you. And now you have 3 people suing the landlord. And a lot of times the landlord has no idea that these people were even living in the unit. So what I've been sort of advising clients to do now, whether it's a simple 1-page addendum, just identify who's on there so you know what's going on and that you're agreeing to it in advance, so you don't have problems later on where all of a sudden you're getting sued from all these different people that you didn't even know they were there, never mind giving them permission to be there. So like I said, I'm handling this a lot lately. I've got like 3 or 4 cases dealing with this. So if you can identify, whether it be an addendum or some other part where you want to just write it in, who you're giving approval to, I think that would be helpful. And also, I don't know why this happens, because it's a relatively simplistic, like form boilerplate type lease that the Florida Division of Realtors puts out, the standard lease agreement, if you will. But make sure you're checking all the boxes. Make sure you're filling in all the blanks. There's a lot of information there regarding, who's liable for certain portions of the unit, what you can and can't do. Pets are a big one. Smoking is a big one. And those are all enumerated within the lease, but a lot of times there's so much verbiage within some of these paragraphs that you just gloss over these sentences and you forget to check a box or you forget to fill in a blank. And, fast forward 5 or 6 months from now, you end up in some type of litigation and you're looking back to the lease, and the lease is, doesn't say one way or another. Well, it doesn't say in your favor because you forgot to check a box. And even though it was discussed with the prospective tenant who ultimately moved in months and months ago, and everybody was on the same page, if it's not on the lease, it doesn't really count. So just be very careful when you're filling out these lease agreements, that you're getting all the boxes and you're filling in all the blanks. And also to my landlord friends out there, don't over agree to certain things as far as your obligations. Chapter 83 of the Florida Landlord Tenant Act has statutory obligations that we're bound by, but there's a ton of items that you can disseminate between the parties and who's going to do what. And a lot of times just landlords are like, oh yeah, I'll do this, this, and this. I had a client who just had this ridiculous arrangement where he would come in and agree to change the light bulbs, physically come to the property to change the light bulbs for the tenant. And I'm like, why would you ever, agree to this? Like, this is just silly. So just be careful on some of the things that you're agreeing to. I know everybody is anxious when you're about to get the lease signed. You want to get somebody in there. You want to start generating income off of it. But you don't need to give up the farm in a lot of these situations. Follow the statute, but be mindful about what you're giving up, and on the reverse, be careful that you're not making the tenant do too much as well. The tenant should not have to go on the roof of your property to patch up a hole. You don't want that. That's a bad thing. You don't want them making structural improvements or structural repairs to your property using God knows who to do that. So just be careful as far as the responsibilities, and really look at the, I know it sounds like something we hear all the time, but read and comply and understand what you're signing and what you're filling out in the get-go, so it doesn't turn into something that comes back to bite you in the butt later on.
Great advice. Thank you. Let's I guess dive into some questions. Some are coming in online. Some came in previously. One that just popped in online kind of piggybacks to what we were just discussing, and I've got it summarized here. Some owners feel that leases work against them, that they're better off just having a month-to-month tenant, that if they stop paying, they can just tell them to leave. I think I know your answer, but I'd love to hear your answer.
Phil, do you want to get that one, or you want to let me handle it?
Yeah, sure. So there's legal reasons and there's business reasons for that, right? Just what Adam said before, right? A lease is going to specify who is responsible for what. If you don't have a lease, you're going to have these issues where you don't know if you're responsible. Who's responsible to fix the dishwasher? Well, if there's no lease, maybe the landlord's position is, well, if the dishwasher works, it works. If it doesn't, it doesn't. It's not my problem. I don't want you taking the dishwasher out to replace it, but I'm not going to fix it. You'll just have to live without a dishwasher and have a broken dishwasher there. Look, you're right. If you don't have a written lease, it becomes a month-to-month lease. And if you want the tenant to leave or the tenant wants to leave, they have to simply notify you, presuming it's from the first to the end of the month. You have to notify within 15 days from the end of the term. And then, right, the tenant would have to leave, or the tenant can leave. But on the flip side, remember, you're running a business, right? Most people who own multifamily properties, they're not doing this for their health. They're doing this to generate income. And if all of your tenants are month-to-month tenants on leases, let's say that something happens in the building. Let's say something happens and maybe you have some sort of termite infestation that's going to take maybe a week or two to fix. Your tenants might just all say, the heck with this place and leave. And you could have a mass exodus and then good luck paying your mortgage next month. So for business reasons, I think it's foolish to not have leases with your tenants. Just telling your tenant that, well, this isn't working out, you need to leave. I don't think that you're ultimately going to have long-lasting tenant relationships with good people, because I know that if I was renting, I would want to have a good long-term relationship with my landlord and not move in somewhere and then move out 3 months later. That's really probably not going to attract your top flight tenants. So again, that's a business point, and having everything in writing is just so important these days. So there's no miscommunications.
And I think just to piggyback on the point, Steve, I think something you also want to consider is this: if really that's sort of how you want to operate your rental property. You are correct in the sense if you have a month-to-month tenancy, you can pretty much terminate it pursuant to the statute and have them out within 30 days, or at least demand that they leave. The problem is, chances are most people are not going to be very receptive to a notice like that, and they're not going to just throw their hands up and say, okay, I'll be out in 15 days. You're probably going to end up in a lawsuit anyway. So if you're going to court, you're going to have to go through the same parameters as if you had a written lease as to whether you didn't. In addition to all the benefits that Phil just outlined, it doesn't really save you anything from a legal vantage point, because you're most likely, with a good portion of those people, are going to end up in court anyway. So why not have anything spelled out so that there's no dispute, so that there's no defense of, oh, well, I paid him this extra, so it was really a 3-month tenancy. It wasn't a month-to-month tenancy. You have the written lease. The document speaks for itself. The proof is in the pudding, as they say. It's going to be very highly unlikely that a tenant is going to be able to successfully negate, the terms of a lease, whether if it's just some verbal thing, a lot of things go up in the air. So for the couple of bucks that it may cost you to consult with a lawyer or a real estate professional to get a solid lease in place, which, by the way, you can, reuse from time to time. It's definitely worth the money and the headache that you're going to potentially face if it's just some sort of, verbal arrangement and you don't have anything written down.
Yeah, you bring up a good point with the deposit and the last month's rent versus first month's rent. Without a lease, who knows what that money is designated for? You could write something on a check, but what does that really mean? So that creates its own issue there, right? The landlord could say, well, no, that was just a fee for you to move in. It's just, I can't advise enough against that question, against that method.
And let me add on to the question a little bit. Would the declaration, a written declaration, as set forth in the CDC guideline, be applicable to somebody who was in a month-to-month lease? Could they declare that they're not leaving?
So I think when you get into that, let's focus back on what the CDC order actually protects. It protects tenants. You can have a tenancy in the state of Florida without a written lease agreement. You can have verbal tenancies, as Phil and I discussed. Probably not the best idea, but they are legal in the state of Florida. So if you qualify as that, verbal tenancy or a non-written lease agreement that you have with whoever, they get the protections of the order. So they can, in theory, file that sworn declaration. And now all of a sudden, again, you can still sue them, but you may have some trouble actually getting them out at the end of the case. So that's not going to, be able to shift your problems away from that CDC order just because you say, okay, well, I'm gonna let this guy in, but we're not going to have a lease. If he's there and if he's a tenant, whether it's written or verbal, he's going to get the protection, or I should say, they would get the protection of the CDC order.
Thank you for the clarification. Now, it's funny, a lot of the questions are tied together from different people, so I'm going to try to paraphrase and not overlap too much. But Francisco asked, he has tenants that can pay and have refused to pay because they said they don't have to and that they can't be kicked out. And to qualify it, they have not given him any type of written declarations per the CDC guidelines.
So first off, sorry to hear about that, Francisco. I know that can be very difficult and very stressful as a landlord. My suggestion is, if that's the attitude that they want to take, you need to file some type of legal action against them to get them out of the property, especially if they have not given you the sworn declaration that's required under the CDC order. Remember, the CDC order is not an automatic thing. It's just not something that you can cite to as a tenant and obtain all the protections. You need to file that sworn declaration under penalties of perjury as a tenant. So it sounds like in your situation, Francisco, if they do have money, they may be a little unwilling to sign something like that and risk, the potential ramifications of lying under penalties of perjury. So at that point, I would suggest take some type of legal action against them immediately. Don't let them continue to reside in your property rent-free, and especially if they're rubbing it in your face and pretending to be lawyers and understanding how this process works. So unless there's a sworn declaration, again, which will only stop a physical removal of someone from the property, you are still free to file the lawsuit. I would definitely suggest that you consult with an attorney and make quick arrangements to explore your legal options, because there's no reason to allow someone like that to remain in your property.
So I want to add something to that. I want all the landlords out there to think about the fact that tenants talk to each other. And sometimes you need to make an example out of a tenant so that other tenants see that you're not a landlord that will allow themselves to be pushed around by the tenants. And so in some ways, it's like having children. If you let one get away with something, then you have to let the other one get away with something. So you really need to be cognizant as a landlord of how you handle tenants who are thumbing their nose in your face, because the one who's doing that is probably telling people about it. They're probably telling people how smart they are and how proud they are, and riling up the other tenants. And typically when you chop the head off of something like that, then everybody else falls back in line, because really your goal as a landlord to provide a safe, clean place for people to live where they can come home at night and feel safe. And nobody wants to come home to a building where they're at odds with their landlord. It's not a comfortable situation. So, people just have to remember that if you let one or two tenants push you around, everybody else will see that. It's just like everything in life. So really need to stand up for yourself. Don't try to do it yourself. If you take that tenant, hire an attorney, and make an example out of that tenant, you will get much better results on the whole in your building.
That's great. And Laura has a question that really is a great segue from Francisco's first question, because he has two. But Laura wants to know, tenant is working, isn't paying, sign a declaration. What's the process for contesting the written declaration?
Sure, and that's a great question, Laura. That's one of the questions that I field the most with my landlord clients nowadays. So the short answer is you can't contest it unless some type of legal proceeding is underway. So as I've mentioned, and I don't want to beat a dead horse on this, but as I've mentioned before, you're still free to sue that tenant. The CDC protections only apply to removal of that individual via writ of possession, which is obviously, as we know, is the last step of an eviction lawsuit. So you are free to sue that individual for non-payment of rent. And once that lawsuit is filed, you and your attorneys have a very handy tool that becomes available to you. It's called discovery. And during the discovery process, you are allowed to request various documents, invoices, statements, emails, correspondence, whatever you can think of relating to the allegations that they've made within that declaration. You're also able to take their physical deposition, make them come, well, they don't really come to anybody's office anymore because of where we're at, but make them sit for a deposition via Zoom or whatever means you and your lawyer decide to come up with, and ask them questions about that. Put the pressure, make them prove what they've said in the declaration. And in my experience with this, when you put that pressure and when you put that heat on people, a lot of times it causes them to fold. I had a gentleman that I was involved in a piece of litigation with that actually filed a notice of withdrawal of his declaration, meaning I'm not going to rely, on my declaration anymore, because we started to put a little bit of pressure on him. So that is really the best avenue you can explore when you are given one of these. What you also may want to check, Laura, when you're going through with this, and I'm happy if anybody wants me to provide a physical copy of what the declaration looks like, because the CDC actually issued a standard form that they suggest you have to use, or you have to use, nearly identical type of form. When you carouse the internet nowadays, everybody has one of these declarations that you can go online. And unfortunately for those individuals who are using the online, the Google declarations, if they don't comply with the same standards that the CDC declaration has, the standard issue form that the CDC puts out, you don't have to accept that. So you may want to compare the two first and make a determination if they've hit all of the elements, because there's enumerated items. There's about 10 or 12 of them that they have to agree to in this declaration that the CDC requires. So if whatever document they gave you does not mirror that, you don't have to accept that, and you would obviously in your eviction action would bring that up to the judge, and hopefully that judge would make a judicial determination that the declaration has no bearing in the case. But even if it's legit, there's ways to put heat on them, and there are ways to basically prove that what they've said is not true. So you really need to explore those, especially if you have an inkling suspicion that this person is just lying to you and just quickly sign the form because they wanted to get you off their back.
Stephen, I want to just add to that, and it really goes to what I was saying before. If you're doing your diligence as a landlord on tenants, and you Google their name, you're going to find out if they were involved in any lawsuits previously, and it'll become very clear very quickly to whether somebody is, a consistent offender, right? And they keep coming back. So, while landlords may feel somewhat powerless when they have tenants who aren't paying and getting, middle finger emojis from their tenants, when they ask them for the rent, when it comes down to it, they can be as brave as they want. But for the people who are brazen and who are not being honest, it's not a good look to have an eviction on your record. It's not even on your record. It's on Google. I mean, Google's worse than having it on your class transcript growing up, right? It's the most permanent thing ever. It's worse than a tattoo. So
it's permanent.
Right? And so, there's a lot of good people out there who are having problems right now. And while Adam and I have taken a very strong position, look, there are people out there that do need help. And the CDC didn't come out with that moratorium because they just felt like being really nice. All right, we have a major problem out there. We're still waiting for another round of government stimulus. And without that stimulus, really, who's that hurting? It's ultimately hurting the tenants and the landlords, because the landlords, for the most part, have to pay a mortgage. And now it's hurting tenants, because now you have tenants who are going to be saddled with a tremendous amount of rent debt that may or may not ever get paid back. And so while we're telling you what your rights are as landlords, of course, in a general sense, every situation is different. There is a time to help your tenants and sort of do your part to help the good actors, because I believe that most people are generally good. It's the bad apples that get the attention.
Well, just to give a little extra color, the CDC guideline, the declaration, is available in multiple languages. Like, I think every language that I've ever heard of, you can get the CDC guideline. But while we're talking, about the eviction process, we're hearing in the field that it's taken a long time, even once somebody is appropriately, even now, able to be evicted, waiting to get them physically removed is taking a long time. What should somebody be doing to make sure that they're in queue properly, that they haven't been forgotten, and are there ways to speed it up?
So unfortunately, that is an additional layer that we are seeing in eviction world. A lot of times, depending on who your judge is and obviously what county you're in, the eviction process, the judicial process, is generally a lot quicker than a normal litigation that people have experience with over other disputes that they may be having with people, especially if the tenant is not contesting or not putting forth defenses. There was a portion of Chapter 83 that was rewritten several years ago that actually requires, when you're dealing with non-payment of rent, that the tenants place the delinquent rent into the registry of the court before they're allowed to actually defend against the lawsuit. And as you can imagine, for those tenants who aren't paying or don't have the money, that's usually a tall task to comply with. So if you're not able to defend against it as a tenant, you're likely going to get defaulted, and the process is going to be relatively swift and quick. The problem that we're seeing is after you get a judgment, after you get a writ of possession, all that does, it allows you in your respective county to call the sheriff and say, I've got this writ of possession for my unit on Main Street, and I want these people out. And you have to pay the sheriff a fee, and then unfortunately you have to turn it over to them. Landlords in the state of Florida are not permitted to execute on their own writs of possession. You have to turn it over to the sheriff for some pretty basic and obvious reasons. So there is a little bit of a backlog in South Florida with the sheriffs, the respective sheriff departments who are executing on these writs. This time of year, I mean, obviously with the holidays, there's a natural progression for things to slow down. Pretty much the week leading up to Thanksgiving until after New Year's, that's just how this time of year works. And a lot of sheriff departments are just busy or short-staffed. So there are some things you can do. There are expedited payments that you can make for increased payments that you can make for an expedited removal process. So as opposed to a couple $100, you can pay $1,200-1,300 to be on the expedited list, and generally the sheriff will go out there normally within a matter of days, maybe a week, to have the individuals removed. But this is really one of those things where, unfortunately, you can push a little bit and you can pay for the expedited proceedings, but you have to wait for the sheriff. You don't ever want to take things into your own hands and try to throw somebody out yourself or change the locks before the writ has been executed upon, because that can subject you to some type of liability. But I guess to circle back, the best way to handle it, if you really need somebody out, is to spend the extra money and try to get on that expedited process with the sheriff's office and hope that they can come out in at least a week or so. I dealt with this last week or about 2 weeks ago in Dade County with a client who paid for the expedited, and I think it was like five or 6 days before they came out. So it is possible, but if you're just paying the entry level fee, it could take weeks for the sheriff to ultimately come out and execute. Because remember, to finish the thought, they've got to go out, they've got to first post a 24-hour notice. That's that red piece of paper that I'm sure us as landlords have all seen, basically giving them 24 hours. And then they got to come back out, which usually takes longer than 24 hours. Usually takes 3 or 4 days before they come back out after the 24-hour notice. So it is a little bit of a process. So if you really need someone out, you have to sort of weigh the cost-benefit analysis of spending the extra hundreds of dollars to do that. But if you need them out, there is a method to get them out quicker.
That's great. And if I can read the small print on my screen, Rita asked a good question. Can a landlord go forward not renewing a lease, or is the situation different because of COVID-19?
As long as the lease isn't set up where the tenant has the unilateral right to exercise an option, no landlord has to renew any lease because if they're not a great tenant for you, again, you can't discriminate based on all the things that you're not allowed to discriminate for. But other than that, you really don't. No landlord has an obligation to renew anybody's lease. Like the standard form lease does not have an option in it. And if you had written a lease with a tenant and it did have an option in it, I really would hope that you would have had an attorney draft that.
That's great. Thank you. Now, Joan asked a question which is near and dear to my heart. She's curious how the pandemic's affected rental rates and property values. Now, what we're seeing in rental rates, ironically, as we're talking to landlords daily, a lot of them got caught with empty apartments in March and April, just by chance or because of a natural vacancy. And people really weren't looking at apartments in March and April. People were staying at home, and it depressed some rental rates in that kind of first quarter. And they weren't getting as much traffic. So fast forward June, July, August, they're getting other vacancies naturally or unnaturally, and they're going back to that same low rental rate with the expectation that COVID's still affecting. And it's really not the case. People are looking at apartments. A lot of landlords are doing virtual tours where they're filming and videoing and FaceTiming through an apartment. And there's ways to generate traffic in an apartment. And some rents have actually increased over what they were pre-pandemic, which has been really phenomenal. So we're tracking rental rates for landlord every week. People are asking us to compare to their competitors and see what they should be charging, because the rates have changed. And in terms of values, it's a really strange dynamic with COVID. A lot of the ownership is sitting on the sidelines right now. There's very limited active listings of appropriately priced properties. And by appropriately priced, a lot of the prices are actually high, because right now we're seeing tremendous flow of capital migrating from the New Yorks and the Californias, South America, Canada, taking advantage of an incredible demand here in South Florida. So we're actually seeing massive demand with limited listings, and prices are actually holding, in some cases going up. So for any of you that want an idea of what's going on at your property with your rents, feel free to reach out to my team. We're happy to take a look and tell you, where they should be and price-wise where you should be, even if you're just holding. It's great to know how you're faring in the pandemic. David asked if the moratorium will be extended. Nobody has a crystal ball. I think you already touched that.
I wish I knew, David. If I had a crystal ball, I'd be buying some lottery tickets tonight. But unfortunately, I don't have any inside information with the Trump administration. So there's no way for me to find out. I'll find out online just like everybody else when the time comes.
That's great. And one question, it's actually an anonymous question. For the tenant that did everything right, they're making under $99,000, they've lost their job, they're using best efforts, and maybe go over what best efforts truly are versus just efforts. And they're paying some rent, but they're running an increasing balance. What happens to that balance, in the real world once January 1st comes?
So there's the practical answer to that, and then the legal answer to that. And the legal answer is the moratorium only stops you from being physically removed from the property as a tenant if you qualify and you meet the conditions of the order and you sign the declaration under penalties of perjury. So it does not negate any of your rental obligations. They continue to accrue. Just like if you go into default with your mortgage payment, the interest and all the other fees that they like to tack on and unpaid principal, I mean, that doesn't stop. So it's a similar situation with tenants who just can't afford to pay it and have actually qualified for it. So that's the legal answer. So if they eventually leave and you want to sue them for all the back owed rent, you have the ability to do that under the lease contract you have signed with them and get those monies if you were so inclined. Now, the practical answer for those folks who, maybe are actually suffering a legitimate hardship, are doing the best they can. Maybe they're paying half the rent. Maybe, they're giving something just to show in good faith that they're really trying, and that they just, you can't draw blood from a stone, right? So those situations, if they're good tenants, you may want to think about coming to some sort of arrangement where, you offer maybe a payment plan, or you agree to waive a portion of it if they agree to pay, a portion of it within a certain amount of time. I've had situations where we're offering renewals and we're just increasing, although we had initially agreed to keep the rent at, $100 a month, we're now increasing it to $150 a month to make up for the lost rent over the last 6 months that the tenant wasn't able to pay because of the hardship. So if they're good tenants and you want to work with them, Phil drafts great renewal agreements, great addendums, great lease agreements. We can certainly assist with getting something in writing for you to, or make arrangements for them to catch up if you want to go that route. If you don't, and you just want to try to collect from them, legally speaking, you have the right to sue them and collect every, penny, including late fees and interest if your lease agreement allows for that. For the non-payment, you can go after them. Absolutely.
That's great. We've got a couple minutes left. I want to be really cognizant of everybody's time, and I really appreciate everybody being here. But Alex had an interesting question. He was curious whether the eviction moratorium should be considered unconstitutional.
So that's a good question, and I'm a little hesitant to get into a constitutional law discussion, but I will say this: the Centers for Disease Control obviously is a federal institution. You're dealing with an arm or a branch of the federal government. They do have protections under the Public Health Services Act. There are portions of the federal code that allow for this, pursuant to the to keep the general population healthy and safe in these emergency type situations. They do have powers to enact measures to prevent the spread of disease. And if you actually get it, if you're a contextual nerd like me and you actually read the entire 8-page order that the CDC put out, they reference several times what the intent and why they were doing this. And the intent behind all this, like Phil said, it wasn't to just say, okay, we feel like being nice today. They wanted to help those people that were affected, and perhaps more importantly, help the American population in general by having people leaving their homes, or in some cases becoming homeless and spreading this terrible disease that we're all dealing with now, as opposed to being able to stay home, quarantine, or do the things that you do at home in a pandemic. They don't want a mass exodus of people not having homes. So to my knowledge, it hasn't been challenged in federal court yet, but I would go out on a limb and say that even if somebody wanted to challenge it, they would probably lose, because the feds have pretty broad sweeping powers when it comes to things like this. So I don't know, and again, I'm not a constitutional lawyer, but I don't know that it would rise to the level of being unconstitutional.
Well, thank you, Adam, and thank you, Alex, for the question. Our time's just about up. This has gone incredibly fast, and we have questions. We could do this for hours, so maybe we continue this sometime in the near future in a part 2. But in the meantime, if people have questions, please feel free to reach out to us. We're here, we're available. These guys are really top of their game, and while they have offices in multiple states, their presence here in South Florida, they're really the go-to team. So all your legal issues, Adam and Phil at Becker Law. If you'd like a complimentary, just a financial checkup on your property, please reach out to my team. We're happy to take a look and let you know where you stand. And oftentimes we help owners increase cash flow, decrease in expenses, and help maintain and improve their property values even in a crazy time like this. So I don't know if Adam, Phil, you want to wrap up, but I really appreciate you being here, and thank you everybody for listening to us.
Sure, I appreciate it. Thanks for having me. And look, you know, these are unprecedented times, but I think we're seeing the light at the end of the tunnel right now. And I think everybody just needs to hold on, deal with the short term, and is gracious, and just do whatever you can to, you know, help people, but at the same time, don't let people take advantage of you. And I think we're going to be getting little bits and pieces of normalcy back together, and hopefully, you know, in the summer or so, we'll be feeling a lot better. And hopefully one of the webinars we do will be all about how property values have skyrocketed. Stephen is so busy, and Adam is dealing with a lot more business litigation than he is with evictions. And I'm looking forward to that. But in the meantime, if you need anything transactional, real estate, corporate, you just give us a call. Thanks for having me again, Stephen.
Yeah, thank you. This was terrific, and everybody stay tuned. I think we'll do a part 2, and we'll get the notices out to everybody. But appreciate all the questions and everybody getting involved. So thank you.
All right, thanks.
Thanks, Steve, for moderating, and thanks again for everyone who took the time out of the day to join us. Hopefully you found it very informative and, dare I say, entertaining. But as Phil mentioned, any of your legal needs as far as your properties go, please feel free to reach out to us. Steve was gracious in us to offer a complimentary value assessment for your property. I would certainly recommend that you take him up on that generous offer. And anything we can do to help, I know we're dealing with things that are unprecedented, but there is a light at the end of the tunnel. And I'm confident that we will get through this and hopefully become out stronger once it's over.
Thanks, everybody.
Thanks, everyone. Have a great day.